Mr. Sheldon, I hope I haven't put you out by asking you to start a little earlier than you anticipated.
Not at all, sir. Good afternoon. So we're grateful for the opportunity to make this brief oral opening statement on behalf of the Secretary of State for the Home Department in her capacity as core participant, which of course is distinct from her role as the sponsor to this inquiry. As you're aware, we've also provided the inquiry with a set of written submissions, which we hope will be of assistance to you. You will have seen from our written submissions of the 21st of June of this year that the then Home Secretary decided not to make substantive submissions to the inquiry at the outset of Phase 1 of Tranche 2, on the grounds that to do so would be inappropriate in the period immediately prior to the general election of the 4th of July. And so this opening statement and the written submissions that accompany it are intended to address both Phase 1 and Phase 2 of Tranche 2. It is important to record at the outset that undercover policing is a crucial tool in tackling serious crime and keeping the public safe. However, the Home Secretary is appalled by the historical allegations under consideration by your inquiry and considers it vital that we now swiftly get to the truth about what happened and ensure lessons are learned for the future. At the outset of the inquiry's evidential hearings in November 2020, the then Home Secretary provided a detailed opening statement that addressed the genesis of the inquiry, the role of the Home Secretary in the Home Office, the constitutional and regulatory framework relating to the Home Office and policing generally, and undercover policing specifically, since 1968, and the relationship between the Home Office and the SDS. We've not sought to repeat those matters, which we are confident the inquiry will have well in mind. The inquiry announced on the 20th of September of this year that the Tranche 2 Phase 2 hearings would be postponed from the 30th of September to today, the 14th of October, to allow all those involved, including the inquiry legal team, additional time for preparation. The Home Office welcomed that decision and notes the importance of ensuring that the inquiry's proceedings are conducted fairly and that the core participants are able to provide the inquiry with fully informed representations. We recognise the constraints under which the inquiry and core participants are working, but notwithstanding these constraints, the Home Office has sought to assist the inquiry with an overview of the legislative and regulatory framework during the Tranche 2 period in relation to undercover policing, along with some preliminary observations on the evidence disclosed to date. However, sir, for reasons which you will be well aware of, it has not been possible to address the full substance of the Tranche 2 Phase 2 evidence, and the Home Office respectfully reserves its position as to whether the inquiry should afford core participants a further opportunity in due course to make representations on the Tranche 2 evidence at some point prior to the conclusion of the Tranche 5 hearings in 2026. So I don't propose to take up time this afternoon by going through the legislative and regulatory framework we've set out in writing, but it is important and we would invite you to keep it in mind. In particular, it is important to note the overarching point that, as you recently observed in your note of the 16th of August this year concerning Module 3, quotes, the arrangements for overseeing undercover policing deployments are now very different from those which obtained in the past. That is certainly true. Prior to the enactment of the Regulation of Investigatory Powers Act 2000, RIPA, in October 2000, the use of undercover operatives was not governed by statute, but was instead underpinned by non-statutory guidance and codes of practice, and subject to rules established by case law and other statements of principle. The introduction of the Human Rights Act 1998, RIPA itself, and the Investigatory Powers Act of 2016 have all fundamentally reformed the legal context in which covert policing takes place. The present position is that all undercover deployments must be authorised at a senior level as both necessary and proportionate to the issue being investigated. Since January 2014, all police deployments of undercover officers must be authorised by an Assistant Chief Constable and notified to the Investigatory Powers Commissioner, formerly the Office of Surveillance Commissioners. In addition, Chief Constables must authorise deployments which last longer than 12 months and seek approval for such deployments from a Judicial Commissioner from the Investigatory Powers Commissioner's Office, as you know well. The level of authority for urgent authorisations, which expire after 72 hours unless renewed, has been raised from Inspector to Superintendent or equivalent. More recently, the Covert Human Intelligence Sources Criminal Conduct Act of 2021 has introduced amendments to RIPA, providing an explicit statutory regime for the authorisation of criminal conduct by covert human intelligence sources, such as undercover police officers. Such authorisations must be for specified purposes and only where necessary, proportionate, and subject to robust safeguards. The Covert Human Intelligence Sources Revised Code of Practice came into force in December 2022. It replaces the previous code, dated August 2018, and reflects the new statutory regime for the authorisation of criminal conduct by covert human intelligence sources within RIPA. So we've set out in writing the very different legislative and regulatory framework that applied within the Tranche 2 period. And the short point we wish to emphasise for present purposes is that the picture is dramatically different today to the one you will be considering during this phase of your hearings. So if I may, I propose to use just the last few minutes remaining to me to make some brief observations about the Tranche 2 evidence that we've seen thus far. As with Tranche 1, the Home Office has been following the evidence of the inquiry during the Tranche 2 evidential hearings with great care. The Department continues to note in particular any issues arising regarding the Home Office's role. The evidence has demonstrated that the Home Office, during much of the Tranche 2 period, continued to provide annual authorisation of the SDS to the Metropolitan Police. It is also apparent that in annual correspondence between the Metropolitan Police and the Home Office up to 1989, letters from the Metropolitan Police requesting approval of the expenditure provided a high-level description of the work of the SDS, with some brief examples of successes, and also provided assurances, again at a high level, as to welfare and supervisory arrangements of SDS officers that were in place. Beyond this process of high-level update and authorisation, the evidence seen to date suggests that the level of knowledge on the part of the Home Office with regards to the operational activity of the SDS was limited, in particular in light of the nature of the relationship between the Home Secretary and the police. The Home Office did not seek to direct the work of the SDS, nor did it monitor the manner in which that work was undertaken. There is evidence, however, to suggest that there was an agreement between operational partners not to inform the Home Office of concerns pertaining to the actions of some undercover officers due to anxiety that the department would too closely examine the work of Special Branch and the nature of SDS sources. Right to say, though, that there is also evidence that on occasion, such as in 1986 and 1990, the Home Office did express direct interest in the undercover activity of Metropolitan Police Service in relation to anti-fascist action and to the activities of extremist animal rights groups following an escalation of their violent activities. However, in each case, we have not seen evidence of any attempt on the part of the Home Office to engage in the operational management of the officers involved in the undercover activity in question. So as you know, Phase 1 of Tranche 2 heard evidence from former undercover officers and relevant civilian witnesses during the period 1983 to 1992. During the course of that evidence, there were, from time to time, questions relating to or broad references to, quotes, government and or government concerns. So, as you will be well aware, government is made up of numerous departments, with the Home Office being only one. And it follows that the term Home Office cannot and should not be used as a euphemism or shorthand for government or for the security service or vice versa. And we are confident that you and your counsel will be vigilant to ensure in this phase of the hearings that when witnesses make assertions about what government did or did not know or do or approve, it is made clear what branch of government is being referred to for these purposes. We understand that the Tranche 2 Phase 2 hearings will hear evidence in relation to remaining officers focusing on animal rights deployments, managers and relevant civilian witnesses during that period. At the time of providing this opening statement, the Home Office is not aware of any evidence to suggest that the department or any Home Office ministers or officials were aware of the deeply disturbing behaviour and conduct of some undercover police officers in their deployments within the Tranche 2 period. Namely, sexual misconduct, the use of aspects of deceased children's identities to build cover legends, or conduct leading to miscarriages or potential miscarriages of justice. On the 3rd of November 2020, at the outset of hearings for this inquiry, the then Home Secretary's opening statement noted that the 2015 report by Stephen Taylor found that during the Tranche 2 period, a small number of Home Office officials were aware of some of the specific groups that were targeted by the SDS, the type of intelligence being gathered, and detailed operational activity during the years in particular 1983 to 1986. He found no evidence, however, that anybody in the department was aware of the SDS practice of using the identities of deceased children to form their legends, or of the risk that SDS officers may form sexual relationships with their targets. He also found no evidence that the Home Office had any direct knowledge of criminal activity and court appearances by SDS operatives that could lead to actual or potential miscarriages of justice. The Home Office remains unaware of any evidence to date that would call those findings into question. As for the determination of whether groups or individuals should be regarded as subversive, the only witness to suggest that the Home Office had any involvement in determining whether a group or individual was subversive during the Tranche 2 Phase 1 hearings was, as you will recall, HN 78. In his statement dated the 21st of April 2022, he stated words to the effect that the Home Office or Home Secretary deemed the Socialist Workers' Party a subversive organisation and or must have considered the SWP appropriate to infiltrate. When questioned by counsel to the inquiry on the 31st of July 2024 about the basis for this view, HN 78 did not identify any evidence to support his assertion, and nor is the Home Office aware of any corroborating evidence from other sources. We trust that any similar assertions that may be made in this phase of the hearings will also be tested just as rigorously for the purposes of determining whether there is any evidence to back them up. So let me just conclude by saying that the Home Secretary supports this inquiry's aims and is committed to her department continuing to cooperate fully with its investigations. She notes your public commitment to publishing a final report in 2026 and awaits your findings and recommendations with great interest. Thank you very much, sir.
Thank you very much indeed.